Morning, everyone. We're going to start right at 10. We have a lot of material to cover today. Start in about a minute. Okay, good morning, everyone. Welcome to the Green, Borlett, and Wheeler Method for Success program on the estate of Pablo Padilla versus Southern California Edison Company case. We think that we have a very unique and interesting program for you here today, and one that you're really going to enjoy. If you're unfamiliar with our Method for Success program, it's a seminar where we present unique, interesting, and challenging cases that we've had and try to give you tips and tricks on how we overcame those challenges, so that you might be able to use those in your own practice. So we think we have a very interesting webinar for you here today that you should find very useful. This case fits that mold to a T. I think it's one of the most unique and challenging cases that the firm has ever had. As you'll hear about in a little bit, this case involved the tragic death of a farm harvester who was harvesting fruit, and he suffered an electrical shock when his ladder came in contact with the power line in the trees that resulted in his death. And the lead partner on the case, Rob Jarchi, is going to talk about the case in a little bit more detail. But this case had a tough fact pattern and presented some significant obstacles that we had to overcome. But we were able to achieve a $4.7 million verdict on behalf of this man's family. But before we get into the program, I just want to let you know that we try to make this as interactive as possible, even though we're all at home today. If you can see on the right side of your screen, there's a program where you can submit questions to us. So we'll be presenting for about an hour, 15 minutes, hour, 20 minutes today. But we're going to try to reserve some time at the end for questions. So if you have questions, you can type them into the box there, and we'll try to get to as many questions as we can. We always get asked to, can you provide sample pleadings from the case, or can you provide the PowerPoint? And yeah, the answer to that question is, of course, we're happy to share. That's what our firm's all about. We want to share our success with you and your success of your own firms. Let me provide just a brief introduction before we get into it. We've got a lot of stuff to cover today, so I'll keep it brief. My name is Christian Nickerson. I'm an associate at Green, Borlett, and Wheeler, and I worked on this case in a very limited capacity and helping out at trial with a witness or two. But the real stars of the show were Rob Jarchi, Molly McKibben, and Sandra Romero, who you see at the top of your screen. And first, let me introduce Molly McKibben. Molly's a classmate of mine from Pepperdine. She's a partner at Green, Borlett, and Wheeler, and I think she's just an absolute rock star. She's obtained numerous multi-million-dollar verdicts and settlements on behalf of her clients. She's been named to, I think, every up-and-coming rising star list for lawyers and women lawyers, and it's all well-deserved. And she was also the recipient of CAOC's Consumer Attorney of the Year Award, and just did a great job on this case. And then on your screen to the left, you see Rob Jarchi's picture, and you also see him at the top of your screen. And he was really the shining star on this case, in my view. Rob was the lead partner who had the courage to take this case on, and I think you'll see when we go through the evidence that he did an absolutely masterful job. It was really, really impressive and inspiring to watch Rob in trial and watch him in action. He's also been named to, I think every best lawyers list that there can be, named the top 20 under 40 in the state of California, and also very well deserved. Many accolades and accomplishments, multi-million-dollar verdicts and settlements. Too much for me to go over here, but all of this information is on our website if you want to learn about more of the presenters. And finally, we have the pleasure of having Sandra Romero with us here today. Sandra is a highly accomplished attorney as well, who did so much important work on this case. And working with Sandra, the thing that impressed me most about her in the limited capacity that I worked on with this case, you can see how much she really cares about her clients, and she really cared about this family and did a wonderful, wonderful job for them. And she has some unique perspectives and highlights about the case, which she's going to share with you today. So that was our team on this case. Again, I want to keep this intro brief since we have a lot to cover. So I'll turn it over to Rob now, who's going to start, I think, with an overview of the case and the facts and what happened. Thanks for being with us here this morning. Rob?
Yeah, thank you, Christian, and thank you, everybody, for being here today and joining us for this presentation. And again, Christian, thanks for that wonderful paid political advertisement on my behalf. But let's get into this case. So what happened here? So this is a death case. This is a wrongful death case. He was 31 years old. He had 2 young children at the time of his death and a wife that lived in Mexico. He had a lot of experience harvesting fruit for several years. And at the time of this particular incident, he was picking grapefruit from trees with a 20-foot ladder, and you can see that in the bottom left portion of your screen. And his 20-foot ladder, while he was placing the ladder in the early morning hours, about 5:20 a.m., before the sun had even risen yet at that time, his 20-foot ladder came into contact with one of these 3 high voltage power lines. These are 12,000 volts. You can see that on the right of your screen. These are not the types of power lines you may have in your backyard or front yard. These are transmission lines. And these lines were measured by the defendant after the incident to be at a height as low as 18 feet 10 inches and as high as 22 feet 4 inches. And Mr. Padilla basically was killed instantly when this happened. So this is an animation that we created so you can get an idea of what happened here. You can see him positioning the ladder, getting ready in the early morning hours when he's electrocuted. This is the kind of above view, which he couldn't see in the dark. You can see the power line, the lowest one sagging at approximately 19 feet. And the contact is made. When this happens, he obviously drops the ladder. It falls onto a tree, one of the grapefruit trees he was going to pick. And this is an actual photograph that was taken by the sheriff after the sun had risen that morning, shortly after the incident. Now let's look at that power line, that 19-foot, approximately 18 feet 10-inch power line. This is a highly unusual configuration. There is approximately 375 feet between these 2 poles. Normally, you'd have a pole in the middle, a pole every 100, 200 feet. And so here we have the power line sagging to 18 feet 10 inches. So what could have been done here? So one of the things that we said at trial that they could have done is they could have raised that power line 6 feet higher to 25 feet. We're going to talk about that a little bit more in a minute. And obviously the ladder does not come into contact. Another thing they could have done here was they could have removed the trees. And we're going to talk about this a little later, but they had a right of way to remove trees that were a danger. And according to the defendant's own line clearing manuals, these trees should have never been there in the first place. Okay, so what was the defense in this case? Well, one of the first defenses was they said these power line heights are safe, and they said the use of this 20-foot ladder, that was totally unforeseeable, and they said it was totally unnecessary. They also said that the power lines complied with the Public Utilities Commission rules. There's actually a general order that specifies what the heights of power lines are to be. And one of those specifies that in a pedestrian area, it only needs to be 17 feet, which is lower than the 18 feet at the lowest level of sag we had here. So therefore, they said they complied. Then, of course, they did what a lot of defendants do in cases. They blamed other parties and they blamed the decedent. There were also some challenges on the damages issues in this case, some significant challenges that Christian alluded to. One of them is, this is a conservative jurisdiction. This case was tried in Riverside. And the economic damages on this case were very low. We're talking about approximately $50,000. We're going to address that, how we got the case to a $4.7 million position, even though the economic damages were $50,000. Then, of course, he resided in Mexico. He was a migrant worker, and underlying all this in this conservative jurisdiction, of course, is this issue of national origin, class, and race bias. And that was something that was kind of an undercurrent throughout the case, and we addressed that. Also, the defense was claiming that he was a migrant worker, and therefore he was an absent husband and he was an absent father. He didn't see his kids. He was gone for years at a time. So that was another big issue that we had to overcome in getting the damages verdict that we obtained. And the damages verdict we obtained, by the way, that was all general damages, non-economic damages. So that's the result of the case, the general damages verdict, 4.7. The jury found SCE, Southern California Edison, 80% responsible, the utility. They found the employer 15% responsible, and they found SNR 5% responsible. And significantly, they found the decedent, Mr. Padilla Ayala, 0% responsible. Okay, let's look at SCE's defenses a little bit more so you can get a feel of what we had to deal with in this case. So what SCE said was that, look, these power lines are everywhere. You can look out your window, you can drive down the street, you see power lines like this everywhere. They said that's the way we make these safe is by isolating them and putting them up in high places where people can't reach them. And they said that basically we can't control people if they're going to do things, engage in activities that are near our power lines, like cranes and ladders of 20 feet that are highly unusual. We can't foresee that. And then they went a step further and they said these trees, they claim the trees were roughly 10 to 12 foot tall, according to some testimony. And they said they didn't need a 20-foot ladder in order to get into these trees. They could have had a much shorter 10-foot ladder and so forth. And that would have been more than enough for them to get the fruit out of these trees. And therefore, it's the employer's fault for supplying this super long ladder. And we couldn't have possibly foreseen that this ladder would have come into contact with the power lines. And they used this photo a lot at trial. And you can see here, these are the high voltage lines, these three. This is just a telecom line that does not have high voltage. And these three, they would say, look how far away they are from the trees. There was no need for them to have a 20-foot ladder to try to get into these trees. So how do we respond to this? So one of the important things we used in this case was the jury instructions. And there is an important jury instruction. If anybody who has a case against a public utility, this is probably the most instruction that you'll have. We use this early and we used it often in our closing statement. And that's KC 416. And it says that people and companies must be very careful. That's a heightened duty of care when they're constructing, insulating, inspecting, maintaining, and repairing power lines at all places where it is reasonably probable that they will cause harm to persons or property. And so what we said is, well, what place is it more probable that you're going to have this sort of an incident than underneath an orchard where grapefruit trees are going to need to be picked? And the only way you can pick those grapefruit trees is using ladders. So they knew that this is the sort of place where they had to be very careful. And we actually used the testimony of defendants PMQ to establish they knew all this. This wasn't some mystery to them. This was all foreseeable. They had notice of it and they knew about it. And he testified at trial that he'd known since the 1980s of the dangers of power lines being over orchards, and he knew that people were going to have to use ladders in that situation. He also said that he knew that they arrive in the early morning hours. Why? Because they're trying to avoid the heat, so they get there really early. And what that means is they're going to get there when it's dark and they can't see those power lines. He also testified he knew that the risk here was death or serious injury. This isn't some trivial injury. This is a serious situation that they had to remedy. And in fact, he said he was aware of an avocado picker that had all of his limbs amputated. And by the way, that was a case that my partners, Brown Green and Chris Spagnoli, tried, and they got an 8-figure verdict on that case as well. So what do we argue to the jury here? So what we said in closing is this is actually the rare case where you could have 3 separate verdicts against the defendant in this case. One verdict could be based on the negligence because the power line heights were unsafe. Another verdict could be because they didn't trim the trees or remove the trees. That was also negligent. And then lastly, we said they also violated regulations. We turned their defense into our offense and said that that was an independent basis for liability. So let's look at the first one, the power line height. So what happened here, this is the location of the incident right here. There was a pole on this side, pole on this side. This particular pole, about 9 months before the incident, was replaced under some maintenance procedures of the defendant. And so when they do that, they actually had a planner come out and plan a pole replacement for that particular structure. And what he did was he actually had to go to this grapefruit orchard and look at the poles and look at the situation. And so what did he find? He found that the grapefruit trees, he said those were a hazard because they were only 2 feet below the lines. And he said he remediated that hazard by designing the lines to be raised to 25 feet minimum clearance to prevent injury and to prevent death. But the problem was he didn't put that minimum clearance into the plan. And to make matters worse, he never inspected the work. So he's just the planner. Somebody else goes out there and builds this thing. And he didn't put it in the plan, so they knew to put the line heights at 25 feet, and no one ever checked the work to make sure it complied with that. So this was the testimony. And by the way, he wouldn't admit this. This was something we got from his deposition. The defense, I suppose, had planned for him to change his testimony from his deposition, and he didn't admit that he identified the grapefruit trees as a hazard. So as you can see, there are quotations around this, and we had to read it to him. Question. And you said on the day that you went to your field inspection, you were looking for potential hazards, correct? Answer, yes. And so one of the potential hazards, there was a row of fruit trees beneath a distribution line, correct? Answer, yes. So he identified the fruit trees as a potential hazard. Now, what we did in the closing is we said, well, what does the SCE attorney say about this in his opening statement? And we juxtaposed that with what the defendant's own employee said he was going to say. And we read this part of the opening statement where the defense attorney said that Mr. Palante will testify he does not recall seeing any problem with the elevation of the lines. Was that true? Question, you didn't leave the power line heights the way you found them. You remediated this, correct? Answer, yes. So in your plan in 2009, after you had conducted your inspection, your plan was to raise the vertical clearance of those power lines, right, sir? Answer, yes. So that directly contradicted one of the promises, so to speak, that defense counsel had made. Now, sir, you were trained by SCE that in any agricultural area, the minimum height in terms of vertical clearance was 25 feet. Yes. And when we're talking about an agricultural area, we're talking about things like orchards, right? Answer, correct. And in your design for the pole replacement, for the span involved in Mr. Padilla's incident, that was the span was to have a minimum 25-foot vertical clearance at the lowest point of sag, correct, sir? Answer, yes. And you know that if you didn't follow that minimum standard, someone might be killed or someone might get seriously hurt, correct? Answer, yes. So they knew why it had to be 25 feet and they knew the consequences. And yet the reality was, even though it was designed to have this 25-foot minimum, it was measured by the defendant themselves to be at 18 feet and 22 feet in the measurement between. We also used the testimony of the defendants and the admissions that they made to show that this was a highly unusual line. So we have 3 folks at least with decades of experience with the defendant saying this is the lowest line they'd ever seen in an orchard or an agricultural area. And also saying, if they saw this line, even 20 feet, and this line was 18 feet, they would call it in as a hazard. And this kind of depicts, we showed this graphic to the jury, what the standards are. So here we have this tree that we said is roughly 16, 17 feet. We have a line at roughly 18 feet, and we've got this minimum standard of 25 feet, and this is really where it should have been, 40 feet. And again, we didn't just have our own experts say that, we used the testimony of the defendant to establish that. So we took Mr. Johnson, who was a foreman. We said in his prior jobs, it was a 45-foot minimum over an agricultural area, 40-foot minimum. And we took the defense expert. He said last 2 jobs was a 35-foot minimum. And our expert said the same. Okay, so now we know about the plan and what it was supposed to be. How about the person that actually replaced this pole about 9 months before our incident occurred? So we took his deposition, and we also had his testimony at trial, and what he said was he didn't even know about minimum clearance standards. He just said wherever he went, he took a one-size-fits-all approach, 18-foot clearance, which coincidentally was the same amount of clearance we had here. And even though there are tools that enable them to measure clearances, they have these extendable fiberglass sticks that are non-conductive. They have measuring increments on them. They can use those to see what the heights of the lines are. He said they didn't even use that. They just guessed what the clearances were. And also significantly, which is going to come into play later, the plan that Mr. Palante drew up for this repaired pole was supposed to have a double cross arm to give it additional strength and support. But he only constructed a single cross arm, and that cross arm later would break under that tension. And when that happened, there was a repair that was made about 6 weeks before Mr. Padilla died, and that's going to play a role here as well. But first, in this 2009 pole replacement that was never inspected by the defendant to confirm the 25-foot minimum safety clearance, that was never inspected. So it didn't meet their own standard of 18 feet. And we argued to the jury, they did not satisfy that higher duty of care. So this is the broken crossarm pole that we were talking about earlier. And the foreman that did that job, what actually happened was 6 weeks before Mr. Padilla's death, they did this repair in the middle of the night. They did it, and they finished the job up at roughly 5 a.m. And they never went back to check it to see if it had been done properly in daylight where they could see the line heights. They had been working basically a 24-hour shift. And the foreman testified he knew these lines should have been 25 feet in height. But he never really inspected it because he couldn't, because it was too dark to see whether or not they would be 25 feet. And of course, 6 weeks later, Mr. Padilla is dead. And this was his testimony. He knew that once a crossarm is broken, you look at all the structures connected to that broken crossarm to see if it's affected anything else connected to the pole. He says correct. And that's important because if something breaks on a pole, it can affect the things that are attached to it. For example, the power lines, right? Answer, correct. So he knew all this. And then we asked him, and you finished the whole job in the dark. You did the work, and neither yourself nor anyone else from SCE, to your knowledge, ever went back after you finished the work in the dark to check the work in daylight to see if these 12,000 volt lines hanging over an orchard were at the proper height, correct, sir? He said, to the best of my knowledge, no. And we also brought out, well, you left the site around 4:35, then you had to drive back to the yard, and you clocked out. At that time, that was about 7. So that was 24 hours consecutively he'd worked. Answer, yes. And in fact, when you look, well, let's talk about this first. Question, SCE policy and common sense prohibits you from working 24 hours straight without taking an 8-hour break, right, sir? Answer, nowadays, yes. So, and I think we argued to the jury that, well, I guess back then it was okay, but now they've realized it's not. Question, and there may have been other times where you've done pole work for SCE where you worked 24 hours straight like this, working on these highly dangerous power lines. Yes. Power lines hanging over the public. Yes. And so this is actually the worksheet for that day. And he wrote the medical reason that he took a break after he finished this work was fatigue. And we argued to the jury that, sleep deprivation, we've all felt that. We all know its effects. It's almost as if you consume several ounces of alcohol. Your judgment gets impaired. You try to get things over with quickly. You may not take the right steps. And that's exactly what happened here. They didn't go back. They didn't check the power line. It wasn't at 25 feet. And you can see that just by looking at it, that it was done improperly. And you can see this line right here is substantially lower than these other two lines. And they should be uniform. They should not look like this. This is something that if they had come back in the daylight, they would have obviously seen something was not done right, but they didn't. And we got admissions from the defendant's own employees that this was wrong. So these power lines had 3.5 feet of variation in height. We had 18 feet 10 to 22.4. And the SCE employee says they wouldn't even find a 1 foot variation acceptable, and they should be uniform, and that if that happens, they have to re-sag the lines. In other words, they got to redo their work. but they didn't here. They did the work in the middle of the night and they just left it that way. So that was the power line heights being unsafe. That was the first basis for a verdict in this case. But then we said, you know what? There's so much overwhelming evidence of negligence in this case. There's another basis, an independent basis, and that is that the trees weren't trimmed or remediated. And so one of the things the defense said here is, well, we didn't need to remediate the trees because we complied with the Public Utilities Commission rules on this issue. And they used Public Utilities Commission General Order 95, Rule 35, which says the radial clearance of conductors from tree branches only needs to be 18 inches. And they said we had more than 18 inches. They claimed it was several feet at various times. But we said it wasn't because they said, well, the trees are 10 to 12 feet in height. And we said it wasn't. But more than that, and this is a case that you can rely upon, Pegastaff versus PG&E, even if they had complied with PUC General Order 95, Rule 35, that does not affect the question of whether or not they were negligent because they have to, these are minimum standards. They have to look at the local conditions and see whether or not it's safe. And a grapefruit orchard certainly is a place where the minimum standard is not going to be adequate. And their own rules established that it wasn't adequate. So we actually obtained the line clearing manual from the defendant. And in that line clearing manual, we used their own rules against the defendant. Remember the 10-foot rule. Keep all trees, equipment, and people at least 10 feet away from electric power lines, their own exclamation point. To eliminate possible contact between trees and overhead electric wires, only trees whose mature height and spread will not grow closer than 10 feet to the wires should be considered. So they're saying trees should be 10 feet away from the power lines. And here's what we have here, because one of the things the defense said was, well, the trees could have been 10 to 12 feet in height. And so we used that against them. Their own question by their own attorney to one of the witnesses that was there, he asked him, do you have an estimate what the height of the trees were on the day of the accident? And he said 16 or 17 feet. Now let's compare that to the line measurements, 18 feet as low as. So we're looking at roughly a 2 feet difference between the trees and the lowest line, far less than the 10-foot that defendant's own rules said needed to be maintained. And what's more, it doesn't get much better than this. The definition of an electrical hazard in their own glossary, it's like saying go to the dictionary and look up the word hazard, says that an electrical hazard exists when a worker, tool, tree, or any other conductive object is closer than 10 feet from an energized overhead electrical conductor. So they're defining the hazard as a tree closer than 10 feet, which these are obviously much closer than that. What's more, they actually say here what type of trees should be planted under power lines. And they say we ask that trees within 20 feet of a power line be of a type that grow no more than 25 feet tall. And so, okay, was a grapefruit tree a tree that would grow more than 25 feet tall that would violate their own rules? Well, their line clearing manual has an answer for that. Citrus trees, grapefruit, they say mature height, 30 feet. So we clearly here have a tree that should never have been planted here in the first place. And what's more is they had the power to remove those trees, and they had done it in the past. So we obtained the right-of-way documents from the 1940s when these power lines were installed that gave the grantee, which is Southern California Edison, the right to clear the right-of-way. And by the way, the right-of-way is the area directly under these power lines where the trees were located, hereby granted, and keep the same free of brush, wood growth, and any other obstruction, and to protect persons from injury or death. So they had the power to remove the hazard, not just to trim it. And they admitted as much. The PMQ trial testimony was he acknowledged they had an obligation to regularly inspect and reevaluate the local conditions for safety over time. So these trees were planted in 2000. The accident was in 2010. So they had once a year for 10 years, they had an opportunity to see that these grapefruit trees were planted there and that they should have been removed. And that's what they had done in the past. They had removed, quote, improper plantings in the past. Or they could, at a minimum, they could have talked to the property owner and said, hey, you can't plant these trees there, let's work something out. But they chose to do none of that. They chose to violate their own rules, and they chose to not trim the trees, not remove them, and let them be within 10 feet of these power lines in violation of their own rules. And we said that was an independent basis for this verdict. So what did the defense say in this case? What was another one of their big defenses? They said that the power line heights complied with the PUC rules. So let's look at the PUC rules that they said they complied with. So what they did, they didn't want to use the current PUC rules. They wanted to use the ones from when the power line was installed, and that was what we referred to as their grandfathering argument. And they said that back under the PUC rules back in 1946, General Order 95, Rule 37, it said that the minimum above ground clearance for power lines was 17 feet in areas accessible to pedestrians only. So what that did for them was they could say, well, this is a pedestrian area, therefore 17 feet was the minimum, and we're at 18 feet. So we are full compliance with the PUC, and we did exactly what we were supposed to do. And this is an aerial shot, again, of the location of the incident. And this is a superimposition of an aerial photograph from 1949, which was stipulated to be at the time of the poles being installed. And it shows that these were back then, this is where the power poles were located. This is the line that went across, and this would have been the area where the incident occurred. And they said, well, look at this. This is just wild brush. This is a pedestrian area. Only 17 feet were required. We said no. We said, rather than just rebut this defense and argue against it, what we did was we converted this defense into one of our affirmative theories in the case. And we said, okay, if you want to use PUC General Order 95, let's use that rule, and let's talk about some of the provisions that you ignored and its negligence per se. So we got this instruction for trial, which was one of the provisions that was in addition to the one the defense wanted. And it basically said, guess what? It has to be 25 feet, exactly what their planner said it had to be, if this was an area along a thoroughfare or capable of being traversed by vehicles, or if any part of the line overhangs a traversable portion of a private or public roadway. And so what we did is we hired a photogrammetrist. And what a photogrammetrist does is he takes historical photos, looks at them, analyzes them, and determines, was there a roadway? And also he figured out, he's the one who put these placement of the power poles where they would have been back in the 1940s from the satellite photo, or at the time aerial photo. And what he said was, this is where the incident was, this is the power poles, and guess what? There's a road that goes under the power lines. And he identified the reasons why this was a road. It met out into the other roads, the striations, and so forth. So under this standard, under their own standard that they wanted to use, it was still 25 feet. We turned their defense into our offense. What else did Southern California Edison say in the case? Well, again, they wanted to blame everybody else, including the decedent. And so in order to prevent an empty chair, we had a lot of parties in this case during this trial. We had 6 separately represented defendants, plus a empty chair employer that we had to contend with at trial. And each of these defendants had counsel of the 6, and some of them had as many as 3 attorneys. So you can imagine that this was a packed courtroom. And we had people that were contractors for Edison. We had people related to the fruit harvesting, including the owner of the property, the fruit harvesting companies, and so forth. And we did several focus groups, and we found, yes, there was liability that could be shared among various defendants in the case, even though we felt the target and the principal party that bore most of the responsibility for this was Edison, and our focus group bore that out as well. But we wanted to make sure we did not have the empty chair. But this also had the side effect benefit of creating a David versus Goliath appearance, because it was just us versus 6 sets of independently represented parties. Now, the negative side effect of that was obviously they had advantages. They could divide work. We had to deal with every single day of trial. In addition to our trial preparation, they would try to spring a motion on us pretty much every day of trial that would take up the first half hour and the last half hour of the case. And they would have a different person speaking that might have different or fresh credibility with the judge. And so that was one of the challenges that created, but we felt that at the end of the day, it was worthwhile. Okay, so in terms of the employer being to blame, this defense, it was true. This was a problem in the case. The employer was not present at either a trial or when this work was done. He basically had a supervisor from one of the other fruit harvester companies supervising, and he never inspected the site. And the defense argued he provided improper equipment. He provided a 20-foot ladder. And significantly, they argued that there were all sorts of OSHA violation regulations, and this was a tough hurdle in the case because these were powerful regulations that they could use in their closing, and they used them. You know, regulations that said the employer is responsible for safe operations and, you know, providing the right equipment. Regulations about how if they got any piece of equipment within 6 feet of the high voltage power lines, that's a de facto violation. And of course, since he was electrocuted, clearly a piece of equipment came within 6 feet, and they're saying that's a violation. That they shouldn't have been providing metal ladders near power lines, that they should have used wood or fiberglass, CCR 3287, that they should have called SCE to de-energize the lines, and they didn't do that. And then they cited other sections in support of that. So we had a lot to deal with here, and Molly's going to talk a little bit about how we kept out OSHA violations, citations that were issued, but nevertheless, we still had to deal with these instructions on negligence per se. So how did we deal with that? So we just basically asked the jury, look, who's in the better position to protect from this hazard? So we got Southern California Edison with thousands of employees, with thousands of years of institutional knowledge on the hazards of power lines versus these fruit harvester companies, and that's not their job. They're in the business of picking fruit, not power lines. And then we said, look, who controls the hazard? Who owns the hazard? It's Edison. And they have a team of people that are dedicated to identifying this known hazard that they know about and to remediating it. The fruit harvesters, they didn't even have the power to move the power lines or to trim the trees and so forth. This was all in Edison's control. And then lastly, and very significantly, we argued that Edison was the one party here that had the equipment necessary to know what height these power lines were. Why is that important? Because one of the key theories we had in the case was from our human factors expert who testified, when you look up at a power line, all you see looking up from the ground is a line in the air. There's no context. So it's very difficult to determine how high that power line is. So if the fruit harvester company goes out there and they look at these power lines from the ground, it's hard to tell whether it's at 20 feet or 40 feet. And the testimony was that the fruit harvesting company, they said they felt the lines were normal and they didn't think they were low. And what's more, the fruit harvester company, they don't have the equipment to measure the power lines. Now, on this point, we had the defense attorney actually help us. So the defense attorney supported what our human factors expert was saying, and we used this in closing argument against him. That one of the questions the defense attorney asked was question, and one cannot even determine what the height of lines are unless somebody goes out and measures them. Correct? Answer, correct. Well, guess what? The only one who had the ability to measure these power lines was the defendant, because they're the only ones that had the specialized fiberglass extending sticks and equipment and so forth to do that. And this was a little bit of testimony from our human factors expert on this issue. He said, quote, Mr. Cruz, the supervisor, had testified that yes, he knew there were power lines there, but he wasn't concerned because he thought they were higher than what the ladders were. That's a perfect example of where the accommodation illusion has fooled him into believing that. Okay, so that's how we addressed the issue of employer negligence. We said Edison was in the better position here. In terms of blaming the decedent, this was a big defense in the case as well. They said that SE gave out public information and warnings against using metal ladders, and they actually went a step further than just arguing that. They took the unusual step here of taking out a billboard right before trial down the street from the courthouse. This is about 5 blocks away. Jurors on the freeway heading to Riverside Courthouse, get on Market Street. This is likely one of the paths they're going to take, and they decided to take out a billboard saying to the public, stay at least 10 feet away from power lines, to emphasize this point and to blame the decedent. We had a lot of discussions about this and how we would approach this, and we actually talked to the judge about it, and it was decided that we would not question and voir dire about this because we felt that only emphasized and reinforced the defendant's strategy. Now, these three are kind of tied together in blaming the decedent, one of the defenses they had. So they said, well, the employer had warned the decedent about power lines. That was true. There were warnings in the documentation that the decedent had been provided. They said the decedent had been to this location before. That was true. They said that the power line's presence is open and obvious. So let's look a little bit at what they had on this defense, and it was not insignificant. They showed this safety rules to prevent contact with high voltage lines. They said this had been shown to the decedent, and it warns to keep all tools at least 10 feet away from high voltage lines. Make sure there are no high voltage lines near the harvesting. Always check for high voltage lines overhead when moving or loading equipment, such as ladders. So this was an issue in the case for sure about blaming the decedent. So what we did is we said, look, I'm actually going to skip to this. This is the supervisor that he actually drove a bus. He picked up all the fruit harvesters in the middle of the night. He picked them up at about 3:30 a.m. And every day he'd drive them to a different field, and they'd arrive in the dark so they could avoid the heat. And he didn't tell them where they were going or where exactly they were going to be. They just drove them there. A lot of people slept in the bus. They'd get there, and then they started picking in the dark. And that's what happened here. So this defense, and this is the timing here, civil twilight at 5:16 a.m. He arrived at about 5. Incident happened about 5:20, and sunrise didn't come up for about 25 minutes later. So this defense that he had been to this location before, that the power line is open and obvious, that he'd been warned, all that goes out the window if he doesn't know where he is and he doesn't know there are power lines there because he's literally in the dark. We also focused on the fact that he didn't do anything wrong affirmatively. This was not a case, as we all have seen, where the person's on drugs or alcohol. He was doing all the right things. He's just trying to do his job. He was wearing the PPE. He wasn't fooling around. He wasn't on his cell phone. He was trying to just earn a living for his family, and he happened to arrive in the dark, and the defendant knew that this was typical for harvesters, and this is why they knew that this was a particular hazard to have these lines so low over an orchard. And the jury agreed, and they found 0% fault on the decedent in the case. And now I want to turn it over to Molly, who did an excellent job keeping out. This was an important issue that the defendant wanted to get into evidence, these Cal OSHA citations that were issued saying that the employer was at fault. And they wanted investigator testimony on that, which would have been probably devastating to our case. And Molly, through her great work, was able to keep all of this out of evidence and to handle this witness to keep it out of evidence. So I wanted to turn it over to Molly.
Thanks, Rob. So obviously Rob discussed, a big issue for us in this case is the fact that there was an employer, there was a good argument for employer negligence, and that employer wasn't there to defend themselves. I mean, they did not participate at all in this case. And so generally in most of your cases where you're seeing employer negligence, you want to reduce the amount of fault that a jury is going to allocate to them because of the workers' comp exclusivity rule. And you want to focus on the fact that Cal OSHA investigators, when responding to something like this, are focusing on a very narrow issue, a very specific thing, and that's whether the person who was killed or injured whether their employer did something wrong to contribute to their injury or whether the person themselves did. So we really wanted to focus on keeping the evidence out. Now, in this case, as Rob mentioned, Mr. Padilla was employed by a company called Gold Grower. And that was the company that actually gave him these tall ladders. And then Cal OSHA, when they responded to Mr. Padilla's death, they actually ended up doing an investigation, creating a report, and then issuing citations for Gold Grower, S&R Farm Labor Contractor, who, as Rob mentioned, was the company that was hired to supervise the workers in the field, and then a misdemeanor plea for Mr. Cruz, who Rob was just showing you some testimony from. So those were all things we wanted to keep out of the case. And we wanted them out to allow the jury to determine fault and allow the jury to buy into our argument, which was that Southern Cal Edison was the best defendant to have prevented his death. So if you could go to the next slide, Rob. So the way that we kept all of this evidence out was through motions in limine. And these are kind of the three main sources of law that you would want to use in order to do that. If you could go to the next slide, Rob. So again, in this case, we're trying to keep out the citations, we're trying to keep out the report, and we're trying to keep out any opinions, conclusions, any sort of expert testimony by the Cal OSHA investigator who responded to this. And if you could go to the next slide. So the first thing that we filed a motion on to keep out of evidence and away from the jury were the citations that were issued to Gold Grower, S&R, and to Mr. Cruz. And this is a pretty slam dunk argument. And I think even in this case, the defendants, once we filed this motion, didn't oppose this portion of it. And California Labor Code 6304.5 specifically states that citations or the failure to issue citation is not admissible in a civil case. So if you just file, in most cases, you should be able to get the defendant to just stipulate to that. But if you can't, you just file a motion with this in it. Any judge is going to grant it. If you could go to the next slide. So the report is a little bit trickier. So the Labor Code doesn't specifically preclude the admissibility of a Cal OSHA report. But those reports, as we all know, contain opinions and conclusions of investigators, or even a documentation of statements that are inadmissible hearsay. So, in our case, we had a report that had statements from our client's brothers, statements from other employees of S&R or Gold Grower that we did not want admitted at trial. And so using the hearsay rule, Evidence Code 1200, argue that those are inadmissible hearsay. And then almost every time you do that, the defendant's going to say, well, this is an official business record, so the business record exception applies. And if you look at this McLean case that we've cited, they're very specific about why official reports like this should be inadmissible and should not be admitted under the business record exception. And in that case, they're actually discussing a police report, but the court actually said that the foundation of the special reliability of a business record exception is the requirement that they must be based upon the firsthand observations of someone whose job it is to know the facts recorded. And so the people who are giving this information to a Cal OSHA investigator, because the Cal OSHA investigators aren't there when the accident happens, they're there and they come and they interview people who saw it. Those persons, those witnesses, they do not have a duty, they do not have a business duty to report that to the Cal OSHA investigator. Therefore, the business records exception does not apply. And the second part that the McLean case discusses is, okay, so if those things that are not hearsay within the report are admissible, like the Cal OSHA's investigators' observations, I saw this tree, I measured this, area of the ground, that stuff is admissible. But because of the hearsay concerns, the court in McLean basically said, well, you can just have the Cal OSHA investigator come and testify about what they observed versus admitting this report that is going to have to be redacted and parsed out. And so using that case is a really good way of getting that report precluded from being put in front of the jury, even though it's not going to be able to prevent you from having the Cal OSHA investigator come and actually testify. If you could go to the next slide, Rob. And then another great argument that you can make to try to keep the report out is just using evidence code 352, which we all know talks about excluding evidence that's prejudicial or creates confusion. And this Kelso case, again, is discussing a police report, but you can use it to compare to a Cal OSHA report in saying that if you put this report in front of a jury, they're going to put undue weight into its official character. And they're going to think that, well, Cal OSHA has the final say in liability, and Cal OSHA has fully investigated the scene and determined the liability of every defendant that's possibly in this case. And if someone wasn't cited or if someone wasn't noted in this report, then they probably didn't do anything wrong. And because Cal OSHA is only investigating really workplace safety and usually employer safety, it's too prejudicial. And so we used Section 352 to get the report precluded from evidence at trial in its entirety. Please go to the next slide. And so then Cal OSHA investigator testimony. That same labor code section actually precludes Cal OSHA investigators from testifying as experts. So they cannot repeat conclusions or opinions that are contained in their report. And this means that when they're called as a witness at trial, they may not offer testimony about the applicable regulatory standard, what Cal OSHA standard applied, what that standard means, or whether any party did or did not comply with it. They can basically just testify about what they observed while performing their investigation. So if you could go to the next slide, Rob. So the way that this played out in our case was we got the Cal OSHA citations that were issued to the employer, to the supervisor, excluded from trial. We got the report excluded from trial. And then we got the Cal OSHA investigator essentially rendered ineffective. The defense ended up calling her at trial, but she didn't remember anything independent of her report. So her testimony was pretty limited. And once the defense lawyer tried to start asking her questions using the report, we made objections, which the court sustained. She ended up just coming off the witness stand, and we didn't even have to ask her any questions because her testimony was so limited. And as a result, the jury put only 50% fault on our client's actual employer and then only 5% on his supervisor. So I think in the end, it was a pretty effective strategy to keep all of that stuff out and reduce the applicability of workers' comp to your case. So thanks, Rob.
Thank you. And I think Christian wanted to talk, because we had so many different parties running around in this case to avoid the empty chair. I think Christian wanted to talk about Prevet and its application.
Yeah, thanks, Rob. That's exactly right. I mean, in a case like this where you have a landowner, you have an independent contractor, you have subcontractors, you have employers, you're probably going to run into Prevet issues. And some of you may have encountered Prevet, and it can be a little confusing and a difficult hurdle to overcome at the summary judgment stage and also at trial. So we just wanted to touch on this briefly just to kind of give everyone a refresher. If you haven't encountered Prevet before, we hope this will be helpful. So what is the Prevet doctrine? Prevet is a case that says a plaintiff injured by his own employer can't sue the company that hired the employer for the sole negligence of the employer. And the reason behind that rule is workers' comp exclusivity, basically. Next slide, Rob. So basically, under Prevet, we've cited the Hooker versus Department of Transportation case. An injured employee like Mr. Padilla can't sue the company that hired his negligent employer if the company that hired the employer can show that it did nothing to cause harm to the plaintiff. So this is often a tough hurdle to overcome, and that's the general rule that you can just keep in mind. Go ahead, Rob, next slide. So a hire has no duty to the employees of the contractors that it hires. Next slide. And so how did this apply in this case? So you've heard about Sunworld and Gold Grower, and those weren't our target defendants in the case, but we had to overcome Prevet issues to keep them in the case to avoid the empty chair, as Rob mentioned. So here Sunworld was the hirer, and what Sunworld did, they hired Gold Grower as the contractor to provide harvesters to pick fruit, and Mr. Padilla was an employee of Gold Grower, and Mr. Padilla dies while attempting to pick fruit. So of course we have to go through the Prevet analysis, which we did on summary judgment with respect to this defendant. So how do you get around Prevet? Here's how you do it. An employee of a contractor like Mr. Padilla could seek recovery against the contractor Gold Grower if any of the following occur. So these are the 3 limitations to prevent that you're going to want to focus on in developing your evidence throughout the case if you think that you're going to have a prevent issue. And in cases like this, you're almost always going to have a prevent issue. So what you want to show, the hirer's own affirmative acts caused or contributed to the employee's harm, or that the hire retained control over some aspects of the work and affirmatively contributed to the employee's harm, or that the hire owes a non-delegable duty to the employee and the breach of which contributed to the plaintiff's harm. So these are the limitations that you want to keep in mind as you're taking depositions, doing document requests, because you're going to need that evidence to overcome the prevent argument on summary judgment. Next slide. And this is just one point that I wanted to make clear here. So that word affirmative contribution, the defense always tries to rely on that and say, well, we need to do some affirmative act in order to be, for the limitation to apply. That's not true. Omissions count as well, and that's under the Hooker case. So I wanted to provide that site. Next slide. So here, how did this, what was the application in this case, and what evidence did Molly, Rob, and Sandra develop to overcome the prevent arguments on summary judgment? So we argue that Sunward was liable for its direct negligence in retaining control over the property in the manner in which the decedent performed the work and affirmatively contributed to the decedent's injuries. So what's the evidence that we use? So we had the contract between Sunworld and the property owner that said they would retain field supervision. That's obviously super helpful on retained control. Sunworld was also regularly on the property. They told the harvesters which trees to pick. Next slide. And Sunworld employees also testified that they'd be present and oversee the harvesters' work. So obviously that's an element of retained control. They instructed the workers to harvest a block of trees, including subject power lines, and met them before dawn to do so. So they knew about the extreme risk or injury, but did that anyway. And also importantly, Sunworld provided the harvesters with the 20-foot ladders, which we've talked about. So that's all evidence that we were able to use to get around this prevent doctrine to show affirmative contribution and retain control. Next slide. And another point that I just wanted to touch on briefly, something that some people don't think about in this independent contractor hire situation, an employee can actually have dual employers, and this is the special general employer rule. So when an employer sends an employee to do work for another person and they both exercise power or control over the employee, it can actually be found to have 2 employers. And so there's the general employer and the special employer. And I've cited the cases here for you. You may want to write down these sites if you think you're going to encounter this in one of your cases. So how did that apply in this case? Next slide. So S&R said it wasn't responsible for the actions of Mr. Padilla's supervisor because the supervisor was a special employee of Gold Grower. But, next slide. Here's the jury instruction on special employment, and I won't read it for the sake of time, but you can see here that this is what the jury was instructed on, and it is possible to actually show special employment and general employment in a case like this. Next slide. So as Molly mentioned previously, the jury actually found that the supervisor was negligent and that the supervisor was actually an employee of both Gold Grower and S&R. So both Gold Grower and S&R are on the hook for his negligence. And again, Gold Grower was found to be 15% at fault and S&R was found to be 5% at fault. Next slide. And now I want to turn it over to Rob, which, I think that this is the most interesting aspect of the case and where the case was really won on about harms and losses and damages. So go ahead, Rob.
Yeah, thanks, Christian, and thanks for that great presentation on Prevent, which even having gone through the case for 6 weeks, I still don't fully understand parts of it. So let's talk about the harms and losses in this case. So that's the decedent with his wife, Maura, and he had 2 young kids at the time of his death at the age of 31. And so we had challenges to overcome that we talked about at the beginning, and I kind of want to go over some of each of these in turn. So obviously we had to deal with a conservative jurisdiction, Riverside, but we also had this issue of very low economic damages. So the defendant actually hired a loss of earnings damage expert, and we took her deposition, and she prepared a report. And in that report, she indicated that when doing the exchange rate from pesos and so forth, that the total past and future economic loss in the case was $54,000. So that was a substantial problem for us. Obviously, in some conservative jurisdictions, you often see in voir dire that a lot of the jurors don't even want to award non-economic or general damages. They have a great reluctance to that. They don't like the touchy-feely pain and suffering and all that. Some of them don't want to award it. And some of them that do want to award it, the danger is if we have $54,000 in economic damages in the case, that the obvious danger is that they're going to use that as a yardstick to measure what the general non-economic damages are. And maybe it'll be 2 times or 3 times or whatever it is. They may just keep it in the ballpark of what those economic damages are and think they're being very generous. So we wanted to get out of this conundrum, and the way to avoid this whole issue was to waive economic damages, just remove it from the table, because we didn't think that the value of this relationship and of this father to these 2 young kids was worth anything near this $50,000 mark. So we eliminated the issue and waived the economic damages. So that's how we dealt with that. On the issue of national origin, class, and race bias, how did we deal with that issue? That was a challenge in this conservative jurisdiction. Well, the first thing we did is we filed a motion in limine. And we made a motion to exclude the country of residence, Mexico, from trial. And we successfully argued to the judge that that has no relevance. And by the way, if we had not waived economic damages, it would have had relevance. So that was an important thing that we did, because if we hadn't waived economic damages, the pesos conversion would have come into play and so forth. So we took that off the table, and we reasoned it out with the judge. And we said, look, the only reason to use this is for an improper purpose. Instead of saying that he's from Mexico or his family lives in Mexico, all they need to know is that he's out of the state of California. And so that was the equitable decision that the court made. We think it was the right decision. And so that in that way, we kept out where the family was and where his national origin was. Furthermore, there's actually an evidence code section on immigration status. So, obviously one of the dangers is they're going to say, well, he's an illegal alien, and there may be jurors who have strong feelings about that. And so keep that out of evidence. There's an evidence code section for that, enacted in 2017, that immigration status is not relevant in a civil case. But you have to go a step further than that. You have to recognize.
Rob, before you get there, can I just real quick? I'm sorry to interrupt you, but I just wanted to remind everybody. So we've got probably 15, 20 minutes left in the presentation, and we wanted to invite you. Again, we've got a few questions submitted already, but if you'd like to submit questions, if you could do so in the next 10 to 15 minutes, we'll try to answer as many as we can. And again, you can type those in on the right. So thanks, Rob. Sorry about that.
No problem. Okay, so this is an undercurrent that you have to deal with. This issue of race, class, all the biases that people have. And so we need to take advantage of the law, because guess what? The law is equitable. The law and the jury instructions are equitable, and they say you are not to consider these factors. You are not to consider race and class bias. And our case as plaintiffs' lawyers, I feel we're on the side of equity. So use those instructions, use them early and use them often. So as you can see in the picture here, Lady Justice is blind when she's holding those scales. And that means it doesn't matter what race you are, what class you are. It doesn't matter if you're a CEO of a company or you're a pauper. When they step into that courtroom, everybody gets equal justice. And so in voir dire, ask the jurors to promise to follow the instructions, to decide the case only on the evidence, not based on nationality, not based on race, not based on class, not based on language. You know, this is an issue we had in this case that, you know, our widow, she only spoke Spanish. And so you need to make sure they're not going to hold that against her. They're going to follow the instructions. In fact, you want them to promise that they're going to follow all the instructions, including considering anything that's outside of the evidence. For example, you know, what they're going to do with the money and so forth. And we'll talk about that in a minute. So, and then also in closing argument, you got to empower the jurors that are on the side of equity and that are going to follow the instructions and act the way they should and act like Lady Justice and be blindfolded to these issues and say, hey, if a juror is bringing up these improper issues and they're violating the jury instructions, tell them to stop. And if they won't stop, send a note to the judge. This is improper. So that's how we battled this in this particular case. Okay. All right. So another argument that SCE made, one of the defenses in the case, was that, well, this was basically an absentee husband and an absentee father. And they had evidence to support this. And this could have been damaging to us. They argued that basically they were apart for over half the marriage. And they were right. You know, he was a migratory worker. He was gone for a year and 3 months, a year and 6 months. And it's true. He did not see his wife. He did not see his young children for a year and a half prior to his death. This was a problem, a serious problem we had to explain to the jury and help them understand. And what we basically said is, look, this is his job. He's a migrant worker. This is what he has to do. And there's equal justice is to be provided for the rich and the poor alike. It doesn't matter if he's a CEO. It doesn't matter if he's homeless. The issue, that's not an issue before you. The issue before you is what was the value of that relationship? Is his life worth any less because his job was to be a migrant worker? And that's how we confronted the issue head on, and to say, of course he was separated because that was his job, and that does not make the value of their relationship or the loss in any way diminished. Okay. So in talking about general damages in this case, so we're obviously in a conservative jurisdiction. One of the things we used here and that I think is helpful is to think about this, and this I think appeals to the jurors with a conservative mindset. Just think about the damages as a math equation. And once again, this is what the jury instructions require. Only consider the evidence. Only consider the magnitude of the loss here. And look at the fact that there's a debt that's owing. There's a debt that's owing due to defendant's negligence on the kind of the two sides of the scale. And defendant has committed negligence, and on the other side of the equal sign or the other side of the scale is your award. We cannot bring the decedent back. We can't bring him back to life. If we could bring him back to life, none of us would be here. The clients would say in a heartbeat, we'll bring him back. But that's not what we're left with here. The only thing we have in the civil justice system is for an award to be made. And it's your job to figure out the other side of that math equation and to figure out what's going to square that debt that defendant made when it acted this negligently and disregarded the safety of the workers and did this repair in the middle of the night after working 24 hours and didn't check their work. What's going to square that debt? And look at the evidence, look at the magnitude of loss. And to help us figure out what number to suggest to the jury, we did mock trials in this conservative jurisdiction. We found what they thought was fair, and that's the number we suggested to them. Now, that's not to say you want to make this a clinical cold equation. You have to connect with that human loss so they understand the magnitude of the loss, because that's part of the equation. What was lost here? When this person, there'll only be one Pablo Padilla Ayala ever, and he's gone, and the dreams of the hopes and futures that the widow had and that the children had for the rest of their lives, those are gone. And you have to figure out what's the value of that loss. And one of the important things in allowing the jury here to connect with that human loss was to allow the widow, when she testified, to connect with the jury. That was so important. And one of the barriers to allowing her to connect the jury, there were actually a couple of them. One of them was the fact that she was extremely stoic. It was very difficult for her to express any emotion. And that was one of the barriers. Another one of the barriers, there was a language barrier. So even if she could express it through words, we had an interpreter that was interpreting what she was saying. So it was important that the jury connect with her on a human level and see the magnitude of the loss, what her husband meant to her, what he meant to the kids. And so in doing that, we had to meet with her and prepare her. And the important thing I would say in doing that, and Sandra Romero, who's a great part of our trial team along with Christian and Molly, she made that happen. She talked with Maura and she found out, and I'll let her address that at the end of the presentation, she found out what it was that broke down that facade and what made her emotional. And so that the jury, doesn't matter if she only spoke Spanish, didn't matter if you didn't speak her language, you could see how much her husband meant to her, what the loss meant to the kids. Once that emotional wall had broken down and she allowed her emotions to come out, the jury knew. The jury knew the magnitude of the loss. And then lastly, I would say, again, I think an important part of any case, not just connecting with the plaintiff, I think connecting with the lawyer. And I think for us to connect with the jury and for us to connect with the loss is very important. And that we have to do it in a sincere, honest way. It can't be phony, it can't be made up, it's gotta be you. It's gotta be who you are and your honest connection. And I had an honest connection with Maura, and what made me feel empathy for her in large part was these young children, and I had young children, and I felt that loss, and I felt a great responsibility because I felt like I was the spokesperson for Pablo, representing these folks, and to say what the magnitude of that loss was. And that helped us, I think, empathically connect with the jury in a sincere way. And I think that was important. And I think that's important for anybody, is to do that in a case such as this. And then I wanted to turn it over to Sandra Romero. As Christian said, an accomplished attorney. She had this case from the very beginning. We worked on it together all the way through the end. We virtually cried together, laughed together, the whole thing for many years through this case. And I wanted to give her an opportunity to talk about the case as well. Sandra?
Thank you, Rob. Can you hear me okay?
We can hear you.
First, Rob is correct in that we had this case for many years, maybe about 5+ years. And when I first got the case, I knew it was going to be a very difficult case. I knew that Edison was going to be a defendant and that Edison was going to fight strong liability and damages. I remember contacting Rob and going to the scene of where the incident occurred, and we still saw the charred grapefruit and leaves, if I remember right. And we went to the scene with one of the brother-in-law who also witnessed the incident. And he was able to describe to us what occurred that day, what he remembers seeing, hearing. And that was very important to do the accident reconstruction, to be able to show to the jury what was heard and seen that day. The family, as Rob mentioned, resided in Mexico, and bringing them into the US for their deposition and trial was quite an obstacle. We had to go through a parolee permit and get them in here through a special visa. And we also had to get somebody to watch over them, since they were being brought here specifically for a deposition and for the trial. Mauda, the widow, and her kids were Mixteco. So their Spanish was not that great. We had to find very simple and basic words to communicate with her and to try and get her emotions out. And that was quite a challenge. I remember working with Rob for several days, just talking to Maura and to her brother-in-law, Pascasio, too, who was also Mixteco, to get them to express to us the way they remembered their spouse and brother. And Maura, I remember when she testified at trial, I don't think she testified. Maybe she said a couple words, but I do remember her just sobbing, and that was very impacting, I believe, to the jury, and that showed the jury really how much this loss was to not only her, but to her boys. The boys were also here from Mexico for the trial. They did not attend the entire trial. They were there for parts of the time, but I think that was also impacting to the jury to be able to see them and how young they were and how humble they were. And they were just good people. And I think you could see that from a distance. Just overall, Edison made it a very tough case. And I'm very, very happy with Rob and his work and his team, Chris and Molly. They did an excellent job fighting back Edison, and I really appreciate everything that you guys did for the family.
Thanks, Sandra.
Yeah, thank you, Sandra. Rob, next slide, we'll get to the conclusion of our presentation. So here's our contact information. As I mentioned, we talked a lot about motions in limine, motions for summary judgment. Rob's closing argument in this case was very impressive. We'd be happy to share all those things if any of you are interested. If you just shoot us an email, we'd be happy to provide you with samples of that information. And also generally, if you have any questions about any of your cases, as I said, one of the reasons why we're doing this program is because we want to help you in your own practices. So jot our names down, jot our emails down, let us know if there's anything we can do to help. We do have a few questions here from the audience, and I'll just kind of throw this out to Molly, Rob, or Sandra, whoever wants to kind of attack this. One question is, what happened after the verdict in terms of a settlement or appeal? How was this ultimately resolved?
Yeah, it's a good question. So the defendant, SCE, appealed it. They fought liability every step of the way, and that included through appeal. It was on appeal for a couple years, and the Court of Appeal affirmed the ruling against Southern California Edison, which had the side benefit of us getting roughly $1 million in interest on top of the verdict.
Okay. Next question. Why did you decide to go to trial? Did SCE offer anything prior to the verdict?
Again, good question. We had quite a few settlement discussions, but long story short is there was not a dime that was offered on the case before trial. So in that sense, it was made easy, at least by Southern California Edison, and that made it easy for us.
All right, and then the last question that we have here that was submitted, did you interview the jurors after? What were their opinions and what did they say about liability and just generally about the verdict?
Yeah, good question. So we did talk to the jurors, and the jurors were not impressed by the grandfathering argument that the defendant made. They felt it ought to be safe now, which is what we argued. And that was a big part of the basis of their liability finding. And, on damages, they were worried about the kids, and they wanted to make sure that whatever verdict came along, that they were taken care of for the future, and that's what their verdict has done.
All right. Well, I think that concludes our program. We want to thank you all for spending your morning with us. We do have another webinar coming up in this series. That's going to be happening in 2 weeks on October 15th, 2020. We hope that you'll join us for that one as well. That's on the Olin versus County of LA case, and that was a really interesting case involving law enforcement and distracted driving. And Bruce Broylett and Alan Van Gelder are going to be presenting on that case. So if you found this helpful or useful, we hope that you'll join us for that as well. And as I mentioned before, I'll mention it just one more time. Here's our information. If there's anything we can do to help you out, please contact us and we'd be happy to do so. So thank you again for spending your morning with us, and we hope that you found this helpful and interesting. Thank you, everyone.
Thank you for joining us.